Besides, there are legal and regulatory requirements. For example, governments worldwide are combating cybercrime and low-level crimes, with a classic focus on intellectual property protection. Essentially, every country has some requirements for intellectual property protection within its information security policies. Intellectual property rights can incur financial costs such as protecting recipes or inventions. Another important aspect to note is a company's reputation. A typical example is the use of Disney characters in animations. If we use a Disney character for news promotion or commercial purposes without Disney's permission, it could result in monetization or use of their animated characters, like producing themed cakes or food items, which constitutes infringement. From Disney's perspective, such actions could damage their corporate image. Therefore, the harm isn't just financial, but also extends to the damage of the business reputation or the commercial trademark of the company or brand. Regarding intellectual property, it includes three aspects that everyone should be aware of. Intellectual property is a broad concept often emphasized in news channels like CCTV 13, where it is repeatedly stated that intellectual property should be respected, including patents. As mentioned, patents cover inventions, creations, recipes, ingredients, and industrial processes that are not easily discoverable. Patents are usually protected for 20 years. As a patent nears the end of its protection period, applications can be made to the Patent Office or Intellectual Property Trading Department to extend the patent duration. Another is copyright, similar to patents, but primarily protecting literary or artistic works. It mainly safeguards the author's copyright, including movies, television, audio-visual products, and music. Copyright generally protects an author's works for their lifetime. After the author's death, in many countries, protection usually extends for 70 years, meaning that descendants still hold certain rights to the copyright. The duration varies by country, but is typically 70 years. The third one is trademarks, essentially the brand's logo, which is the most visible aspect. Trademarks can be thought of as similar to patents because they are commonly used in business settings. Typically, trademarks are protected for 20 years, and renewal depends on specific circumstances at that time. Additionally, various countries impose import and export restrictions on electronic and military products, including weapons, algorithms, and some high-tech applications, the most famous of which is the TheWassenaar Arrangement. The TheWassenaar Arrangement is an international and regional agreement aimed at maintaining security and stability, with laws controlling imports and exports mainly to prevent the enhancement of military capabilities of certain organizations or countries. Initially involving over 40 countries, it includes regulations on the export of certain types of weapons and equipment, which everyone should be aware of. The TheWassenaar Arrangement mainly targets the control of weapon exports. In addition to the protection of intellectual property and weapons, another aspect is privacy, as we've discussed. This includes the collection of personal information, which involves details that may be considered very private, such as citizens' ID numbers, addresses, and phone numbers, information that should not be directly disclosed. The OECD was the first to propose 8 principles of privacy protection, which are crucial because privacy protection should be carried out legally and transparently, allowing data subjects to be informed. Consent is necessary, along with an understanding of the consequences if the information is disclosed. Even with informed consent, it's important to note the first principle, which is to limit collection based on necessity, which is vital. We collect owners' private information mainly to facilitate our services, making it more convenient for users. Beyond this, we should avoid collecting personal information as much as possible. Each country, including ours, since the enactment of the Personal Information Protection Law in 2021, emphasizes this point. originally proposed by the OECD through 8 core principles. So the first principle is the greatest respect for privacy is not to collect it at all. Before we talk about subsequent protections like encryption or disclosure, minimal collection is actually the greatest protection of personal privacy. Moreover, if we are to disclose or make public any personal information, it must be with the informed consent of the owner, approving whether this information can be publicly disclosed, which is crucial because the essence of disclosing information is exposing personal privacy. Thus, doxing is illegal, whether in China or other countries, as it is discouraged by law. The essence of doxing is obtaining a public figure's or an individual involved in a well-known incident's private information through the internet or other channels and then publicly releasing it, which is problematic. Thus, among these 8 principles, informed consent and minimal collection are key principles. You can understand it this way. Disclosure is either public, where I, as the data holder, release the information openly, or it can be a leak due to my security standards not being up to par, potentially leading to hacker attacks. For instance, operators or certain internet service providers may get hacked, resulting in their databases being leaked. This could lead to data being publicly exposed, thus constituting a passive leak. Therefore, whether the exposure is active or passive, there are legal responsibilities associated with the privacy violation that everyone should be aware of. As we can see, countries like the USA, the EU, and the UK have specific requirements. As I mentioned earlier, our country has the Personal Information Protection Law, which specifically protects the personal privacy of Chinese citizens and is often abbreviated as the PIPL, Personal Information Protection Law.